Mr. Beneke, can you hear the court okay?
Yes, Your Honor.
All right, going to go ahead and call your case. Give me just a moment. We are on the record in cause number DC 22-13525, Mark Beneke versus Brian Beneke et al. May I have you to announce on the record? Let me know your name and who you represent.
Mark
Your
Beneke,
Honor.
pro se.
All right, thank you.
Your Honor, Chad McLean, representing Ron Beneke and Jane Beneke, beneficiaries of the 2020 trust collectively.
All right, thank you. And this is Mr. Beneke, this is your motion, is that correct?
Yes, Your Honor.
All right, let me go ahead and hear from you with respect to your motion.
Your Honor, before Mr. Beneke starts, I actually have an objection that I would like to make, and this would be a running objection, Your Honor.
One second, let me switch the camera over to you if you don't mind. Actually, you know what, counsel, if you'll sit.
Would you rather me sit at that table? Your Honor?
Yes, because
Happy to do it.
the camera catches that counsel's table.
Happy to do it, Your Honor.
No problem.
Sorry about that.
No problem. We should have told you in the hybrid hearing that that one catches.
Is that better, Your Honor?
Yes. And you can see up on the screen there that you're in view now.
Yes, Your Honor.
And if you can be seated for the hybrid part of the motion, the microphone allows Mr. Beneke to hear you better. But counsel, you can go ahead and lodge your objection that you were mentioning.
Yes, Your Honor. I have an objection to the court's consideration of any filing by Mark Beneke. As we've discussed previously in hearings, Mr. Beneke is here as the trustee of the three Beneke 2020 trusts. As the trustee, he's here in a representative capacity, not in his individual capacity. Therefore, he is not able to go forward on a pro se motion. Under Rule 7 of the Texas Rules of Civil Procedure, a party individually is allowed to represent themselves. However, they are not allowed to appear in a representative capacity for a trust or for an LLC or corporation. And specifically as it relates to the trust, Your Honor, there are two cases I'd like to bring your attention to. One is the Henry Guttersall case, and I have a copy of that if you'd like me to bring it up with highlights, and the Sharp versus Fung case. Both of those, the Guttersall case is 2010 out of the Amarillo Court of Appeals, and the Sharp v. Fung case is a 2021 case out of the Austin Court of Appeals, and stand for the proposition that a trustee in his representative capacity cannot appear pro se, and any filings of a trustee allegedly pro se constitutes the unauthorized practice of law and should be disregarded by the court.
All right.
I can bring those cases up, Your Honor, if you'd like me to.
I'll have the bailiff retrieve them from you. Mr. Beneke, a response to the objection that you've heard counsel raise?
Yeah, I mean, that's the whole reason why I'm reaching out to you, Your Honor, today, is that there's a fundamental fairness issue here. I can't defend myself pro se, as the court kind of ruled, but I also can't afford counsel. It's a circular problem. In essence, I can't represent myself pro se. I'm facing, an imminent MSJ hearing. I can't personally afford, the required legal retainers. I have a right to defend myself against removal as a trustee, but without counsel, I risk losing all that by default. So it really is a circular issue here, and looking to the court to help me figure out how to solve it.
Mr. Beneke, I understood this motion to be an emergency. And we have had this particular issue prior. Texas law basically is that you may not represent a trust unless you are an attorney. And you are not an attorney. We had that issue before. So nothing has changed in terms of you reaching out to the court to help you figure out how to do that. I can't change the law. I'm here to interpret the law, but I cannot change the law. Just like you have to be an attorney to represent a corporation, even if you are the president of the corporation and you need legal representation, you have to actually go and find a lawyer to represent you to do that. So I'm not real sure what the emergency is because we've had this issue before on other particular hearings. And to my knowledge, you are not a licensed attorney, so you cannot file motions on behalf of the trust and ask the court for relief. In terms of an emergency, when my staff hears that it's an emergency, we do our best to accommodate someone. But it's frustrating for the court when we get in here and find out it's not really an emergency because this has happened before. And I'm not going to rule any differently than I've already ruled.
Your Honor, I have tried to source an attorney here. And what I've found is the complexity of the case requires a minimum $50,000 retainer. So I can't actually afford to hire counsel as these people are kind of filing this against me. I just can't even, represent myself. Ron Beneke controls, fees that are owed to me that I could, utilize to pay for an attorney, but he's withholding those. The trustees of, the 2020 trust spent $2 million on their own, counsel, but my small $50,000 request is being denied. It's just
let's be clear about what is being denied. What is being denied is you may not represent the trust. That's what's being denied.
understood.
You have to be a lawyer.
Yeah. So if I can't afford counsel and I can't speak for myself pro se on behalf of the trust, then by, I guess, logic, there's nothing for me to do except face the consequences of whatever MSJ the other side has pushed out.
That is where we find ourselves today. You are going to have counsel. I understand that you're saying you have not been able to find counsel. It seems like the only counsel you have been able to find are those that want some type of $50,000 retainer. I cannot change the law for you.
Understood. So I guess I'll just be silenced, I guess, is the only thing I can do here, and just let them.
Well, let's be clear,
Yeah.
because you are not an attorney, you may not file a motion on behalf of the trust and ask for relief on behalf of the trust.
But they're also seeking personal damages in their cross claim.
Correct.
So I can't
Correct.
represent myself
You
personally,
cannot represent the trust.
even if the damages are like $2 million of personal damages against me. I can't.
I will say it again, you may not represent the trust.
Yes, Your Honor.
Okay? Anything further, counsel?
Yes, Your Honor. I just want to respond to one thing Mr. Beneke
Okay,
said.
hold on one moment. Let me let the camera pan over to you. Hold on a moment. All right, you may proceed.
Your Honor, the motion that Mr. Beneke is trying to have continued has nothing to do with any personal liability against Mr. Beneke himself. In fact, Mr. Beneke, not individually, in his individual capacity, has not asserted any claims, and no individual claims have been asserted against Mr. Beneke in his individual capacity, and he hasn't been served or appeared in his individual capacity. If we look at the motion that's set for November 21st, it's against Mr. Beneke in his representative capacity to have him removed as trustee for various reasons. So, Your Honor, to the extent he's talking about personal liability and personal risk at this next hearing, the short answer is there is none.
All right. Counsel, based upon the argument that I've heard and the objection that I've heard here today, I am going to grant your objection. Do you have a proposed order that the court can review?
I've got an order denying Mr. Beneke's motion, Your Honor.
Okay, if you would present the court with that proposed order.
May I approach, Your Honor?
Yes, you may.
And this is the same order that's been on file with our motion, with our response, Your Honor.
All right. You can return back
Thank
to
you, Your Honor.
counsel's table. Mr. Beneke, I've just signed an order denying your emergency motion for release of trust funds and for legal representation and continuance of the motion for summary judgment hearing that is set on November 21st at 9:30 a.m. This order will be uploaded by the close of business today. Is there anything further at this time?
No, Your Honor.
All
Nothing
right.
further, Your Honor.
That concludes our hearing. Thank you.